Good afternoon. Oh, you can hear me. Hello. My name is Aleksandra Kuznicka, Cholewa, and I have a pleasure to chair the next session in which we will focus on UPC approach to resolving SEP disputes. I prepared some introductory speech, but Professor Joseph Drex already took it from me at the beginning of this conference. So all that was said will be true for this panel. So we will discuss recent developments before the UPC courts with respect to SEP-related judgments in Panasonic, Oppo, and Huawei Netgear cases. We will discuss the amicus curiae brief of the Commission. So moving to our esteemed speakers, I would like to introduce Dr. Matthias Zigann, who is a presiding UPC judge of the local division Munich, and who was presiding judge and rapporteur in Huawei Netgear SEP infringement case that I just mentioned. We have also Clio Zois, who is a member of legal service at the European Commission. And we have Professor Rafał Sikorski, who is a law professor at Adam Mickiewicz University in Poznań, Poland. With my first question, I would like to move to Dr. Zigann and ask about your overview on what is the general approach of UPC in resolving SEP disputes. We have just heard what is the UPC approach, the UK approach, and I would like to ask on what is your opinion, taking into consideration already those two judgments that we have on our tables. What is the UPC approach to SEP disputes in particular? What are the conditions for granting injunctions? And whether UPC will determine front rate, for example, as a result of counterclaim. For those initial, we'll turn to Clio. I understand that you were involved from the side of legal services at the European Commission in the works of the EC on the amicus curiae brief, which was filed in voice Azure proceedings. Are you able to share with us reasons behind filing this letter and elaborate on EC position with respect to the steps in particular that should be taken to fulfill Huawei ZTE framework, in particular the order of assessments of SEP holder offer and counter offer?
Certainly. Thank you very much, Aleksandra. Thank you very much for the organizers for inviting me to speak at this conference. The usual disclaimers apply. Any views expressed are purely my own and do not represent or by the European Commission. I have been given... Perfect. I've prepared a small PowerPoint in order to be able to present the content of our amicus curiae submission in the most efficient way in the 5 minutes that I've been given for my intervention. And in my talk, I would like to discuss two things in particular: the background of our intervention, in particular, the legal basis, the reasons and the scope of our intervention, and also, secondly, the content of our intervention. I'll make some preliminary observations. I'll talk about steps 1 and 2 of the Huawei framework, which were covered by our intervention, and I'll make some procedural points, including on the order of steps. Let's quickly go into the background. What was the background of our intervention? As you probably all know, the Commission, on the basis of Article 15.3 of Regulation 1003, can make submissions before national court, can intervene as an amicus curiae when the coherent application of Articles 101 and 102 so requires. And this is exactly the reason why we intervened in the case before the Higher Regional Court of Munich, to ensure the coherent application of the Huawei framework of Article 102. Because more specifically, the European Commission had noticed that in these voice HMD cases, there were two judgments by two lower German first instance courts, the one of Mannheim and the one of Munich, that on practically the same factual basis came to a different legal outcome with regard to, in particular, 1 and 2 by framework. This is the reason we decided to scope of our intervention was limited to discussing how, in the Commission's view, the Huawei framework should be interpreted. We did not take any position on how the case should be factually decided as a matter for judges to do so. Very well, let's quickly go to the content of our intervention. A preliminary remark. Our interpretation of the Huawei judgment, we try to stay as closely to the text and the objectives of the judgment itself. I'll go into the text in a second when discussing our interpretation of the first and the second steps of Huawei. But with regard to the objectives, I would like to recall paragraphs 44 to 55 of the Huawei judgment, where the European Court of Justice says there is a tension, obviously, between the objectives of IP law, which seeks to guarantee exclusive rights, and the objectives of Article 102 TFEU, which seeks to guarantee effective competition by preventing or sanctioning an abuse of dominant position. As a result of this tension, a balance, and this is very important, needs to be found between the interests of a SEP holder and the interests of a SEP implementer. And this fair balance, I'll repeat it multiple times in my intervention today, this is key to the background of our intervention. On the one hand, a SEP holder cannot bring a prohibitory injunction against the implementer without giving the implementer the opportunity to conclude a license on friend terms. At the same time, an implementer cannot invoke a competition defense without having constructively participated to the negotiations. So this is a preliminary remark I would like to mention before going into the content of steps 1 and 2 of the Huawei framework. Let's go to step 1 of the Huawei framework, the infringement notice. And here I would like to quickly point to the text of Huawei, which in our opinion mentions precisely the 3 conditions to which an infringement notice needs to comply, being, first of all, there needs to be an alert of the patent infringement. Second, the SEPs concerned need to be designated or named. And third, the notice of infringement need to specify the way or the manner in which these SEPs have been infringed. Hence, in our view, a mere link sent by a SEP holder to a SEP implementer, which to a general website of a SEP holder, which would allow an implementer to merely deduce the fact that there has been an infringement, to merely deduce which patents it would concern, in our view, might be insufficient in order to qualify for step 1 of Huawei. I go to the second step, willingness to license. So this is an obligation on the SEP implementer. And here, again, I would like to point to the text of Huawei. If you look at paragraph 63 of Huawei, you will see that there is actually no specific requirement mentioned therein for willingness. The text merely says the alleged infringer must express its willingness to conclude a licensing agreement. This willingness, in our view, must be assessed based on the content of the implementer's reply and not on its subsequent conduct during the investigations. And I'll come back to that point in a second. Thirdly, this doesn't follow from paragraph 63, but from paragraph 69 of Huawei. An implementer may reserve the right to challenge the validity or essentiality of the patents, and this does not affect its willingness, it being a willing licensee. Very well. I'll come to 2 final procedural points. And here I would like to return again to the objectives of Huawei, which I mentioned at the beginning, namely to ensure this balance and a fair balance of interest between the interest of the SEP holders and the SEP implementers, and to allow these meaningful negotiations without opportunistic behavior from the parties. This entails, in our view, that the sequence of steps in Huawei is a mandatory one. If you look at the various steps, how they have been constructed by the Court of Justice, which have been sort of schematically referred to here in this picture, you will see that every step requires, in turn, an action from the SEP holder, an action from the implementer, an action from the SEP holder, an action from the implementer. And if these steps are not followed in this order, this would, in our view, disturb this really careful balance, which the Court of Justice has sought to make between these various interests involved. For instance, if one were first to require a SEP implementer to come with a friend counteroffer, step 4 of Huawei, before the SEP holder has come with a SEP friend SEP offer, step 3 of Huawei, this would allow, in practice, the SEP holder to seek a prohibitory injunction without itself having made a friend offer first. At the same time, and this comes back to the point I was making before about the willingness to offer, one cannot assess the willingness to receive a license, which is step 2 of Huawei, based on behavior subsequently during negotiations. For instance, the ability of a SEP implementer to make a SEP a friend counter offer. This is step 4. This is the first procedural point. My final procedural point, and it also follows again from this fair balance of interest, which Huawei, in our view, seeks to guarantee. After a prohibitory injunction has been filed, no curing of the various actions can take place, because again, this would deprive this really careful balance and this careful procedure of its purpose. SEP holders might be incentivized to immediately file an action for injunction, while SEP implementers might be then incentivized to immediately invoke a competition abuse. And this wouldn't allow precisely for this pressure-free environment of friend negotiations that the Huawei framework seeks to guarantee. So this is, in a very small nutshell, the content of our amicus curiae as we filed it at the Higher Regional Court of Munich.
Thank you for this nutshell and for such an understandable approach to that. And now I will turn again to Dr. Zigann. I would like to ask you what was in fact the impact of the EC amicus curiae brief in the proceedings in Huawei Netgar case, and taking into consideration what was said by Clio, I would like to ask what is UPC position on how and if UPC will determine if the front offer is filed by the patent holder is friend or not. Reaction, and can you also share what is the current status of the amicus curiae brief?
Yeah, thank you very much, Aleksandra. Interestingly, when hearing Professor Zigann speak, I think there are quite some points on which we are actually aligned. Maybe to start with the final point, which Dr. Zigann mentioned, that one cannot assess whether the counteroffer is friend if one doesn't have the basis of the offer which is friend, which is actually precisely required, in our view, by Huawei by first looking at step 3 and then looking at step 4. As to one of the first points, which Dr. Zigann mentioned, that it wouldn't be for the European Commission to determine the facts of the case. Obviously, it isn't. This is what I mentioned, of course, at the very beginning. It will be for a national court to assess the facts. It's probably ultimately for the Court of Justice to really point us and to really explain what precisely is meant by Huawei if there is a further preliminary reference. So maybe because I know time is short, your second question, Aleksandra, concerned what's the way ahead. So we have been informed that the judgment in the case in which we intervened is expected on the 6th of February. And what is then next? There might be a leave to appeal this judgment, and there is a question: will the Commission perhaps intervene again on appeal? This is a question. So for us, if we were to intervene on appeal, we cannot exclude it, but any such decision to intervene again as amicus is subject to a college decision and subject to a consultation with all the various DGs concerned. So if within the Commission there is a view that we should intervene, and if all the various DGs concerned agree like they agreed for our intervention here, we might do it. But voilà, this is what is to be expected. It's going to be an interesting spring in the field of in the field of our case. Absolutely.
Yes. So thank you for that. We look forward. And now I will turn to Rafał. Thank you for waiting patiently for your turn. I will give the floor to you, and I would like to ask you what is your view on the interpretation of Huawei ZT framework, which was adopted in UPC judgment Huawei Netgar, in particular taking into consideration also European Commission position and in relation to this order of assessment of SEP holder offer and implementer counter offer.
Thank you very much, Aleksandra, for that question, and thanks a lot to the organizers. You can imagine how difficult it is for me to have to speak after so many excellent speakers, and especially judges, and Lord Justice Arnold and our German colleagues here. So it's an extremely difficult task right now, but I'll try. As I was coming here, I was just trying to read again ZT Huawei, the Court of Justice decision. I was also trying to read some of the decisions of the English courts on that, especially the first of those decisions, hotly debated, Huawei Unwired Planet. And I think that my first impression would be after having read the letter, the position the amicus curiae presented by the Commission in the German proceeding, is that I don't necessarily agree with this very formal approach towards the ZTE Huawei. I think that it doesn't have to be that formalistic. You don't have to have step by step, one after the other, and if you wrong on one of them, you cannot move further. I do not think this was the intention of ZTE Huawei. If you read the judgment very carefully, the court is, of course, it specifies the various steps. One goes after the other, but it also then says that you really have to then make the assessment of the specific legal and factual circumstances of each and every case, and only then make a decision. So looking at this, I would probably much more side with Justice Bers, and now Lord Justice Bers, who in this Huawei Unwired Planet decision said that this is more of a model, more of a framework, something that you would look at that could give you a signpost for a safe haven. But this is not, it's not the only way of going with your friend defense. I think the reality is much more rich. There are more offers, more counter offers. The dynamics of the negotiations is far more rich than we can imagine, and that is described through the various steps in ZTE Huawei. But this has, of course, consequences, and I think that if you look at the decisions and the line of decisions by German courts, I have always been very impressed, and this is what I always say to my students, that you have to study the decisions of the German courts. But if you look at this, I think this had a certain effect on the jurisprudence of the German courts, because the German courts very much concentrated on this process. And we have a whole body of German jurisprudence explaining the various steps and explaining what you can do, how you can inform, how you can express your willingness, what amounts to the unwillingness, what is the willingness, can that be done directly, indirectly. There's plenty of explanations in the decisions of the German courts. Some of them very helpful, some of them more obvious, less obvious. But this really creates this what might be something that lawyers will consider a set of traps that you might fall into. I'm not saying, of course, that these traps are set by the judges. Of course not. I'm sure that's obvious, that this is all done in good faith. But if you concentrate on the process itself and not on the commercial essence of that dispute, you might end up with that. And this, I think, is what we've fallen into in those cases. Now, as to determination, as to what I think about determination, of course, these disputes commercially are about setting rates. This is about how much, as Lord Justice Arnold said. And the question now is, because it is the question of application of Article 102, I do think that this is, of course, you have to remain within the limits of procedural constraints and the notion of the claim, etc., that you do have in German law. But then you also have to look at this as a question of European law. And I think that the whole Huawei ZTE judgment is about trying to create conditions for the parties to get to a license rate that's at a level that would not be influenced neither by holdout nor by hold up. Yeah? So we try to recreate those conditions for those hypothetical conditions for negotiations. This is the very essence. And I think ZTE and Huawei is about getting to the friend rate at reasonable and fair conditions. And I think that I'm not surprised that ZTE Huawei also speaks about setting rates. In one of the paragraphs after mentioning those steps, it says that if the parties cannot agree on their offer and counteroffer, they might refer to a third party, might be an arbitration body, an arbitration court. I think it was in the opinion, it was mentioned explicitly in the ZTE, but I fully decide upon the friend defense. You cannot decide the question of friend determination. If you really want to, if you want to get to the bottom of it, and take into account the commercial realities and the very purpose of that decision, you cannot go without friend determination. So I would say that this would be the outcome for me of the application of Article 102 and of the reading of ZTE Huawei. I think there would be an obligation to go into this, to fully decide in an informed, substantive way on the friend defense. But I also think that this, as Lord Justice Arnold said, I think that if you look at this question from a contractual angle, you could also come at some point to this conclusion. Or if you look at this issue from a remedies angle and the EU the directive on intellectual property enforcement and the requirements that injunctions should not be abusive and that they should not limit trade, then I think you also might come to that conclusion that to decide upon proportionality or disproportionality of an injunction in a dispute like that, you would first have to set a rate and then move on with the injunction. So looking more broadly at European law, I think that you might make a case for European law, EU law, being the source of an obligation to get into friend setting in a substantive, serious way. Where we end up right now, I think that we end up with just tremendous discrepancies between what comes out of the rates that come out of the German proceedings, and, for example, the proceedings by the courts in China. I know the global disputes are probably not because of patents. There are more reasons to the global disputes these days. But I'm not surprised that the Chinese courts say, wait a second, our companies, even if that is not direct, or even if that is just indirect sympathy for their own companies, but if the differences are so significant between the setting and rate setting in China and what comes out of the proceedings in continental Europe, then I'm not surprised that we then have disputes like that over who should set what friend rates, and I'm not surprised that we end up with disputes at the WTO about these issues. So I think that to sum up, I would be a bit more creative about what comes out and what is necessary to achieve full effectiveness of European Union law in this respect. Not only competition, but also EU regulation of the IP enforcement.
Thank you, Rafał, for sharing your views from the perspective of European law. And I would like to give a floor to to all speakers in this panel to provide your final comments on what was said. Dr. Zigann.
Thank you very much, Aleksandra. I would just on a personal level like to respond very briefly to Dr. Sikorski's point that the approach of the European Commission in amicus curiae would have been too formalistic. For instance, Dr. Sikorski mentioned, well, if you are wrong, you cannot move any further. And I would like to just recall the context in which the preliminary questions were made in Huawei ZTE. Those were not made in the context of a FRAND determination. The question asked to the European Court of Justice was not, what is a FRAND rate? No, the questions asked to the Court of Justice in Huawei ZTE when is the issuing of a prohibitory injunction, which goes very far, when is that an abuse of a dominant position? And it is, I think, in this light that the approach and the various steps of the Huawei intervention have to be assessed. And it is also in this light that because the consequences of a prohibitory injunction are so severe in a way, and so impact the possibility of parties to negotiate between themselves the FRAND rate, this is why the court came up, in our view, with such a system of the various steps, and why this fair balance of interest needs to be achieved. This is the final comment.
Thank you. Rafał, final comment from your side.
I shouldn't challenge the Commission anymore, but I think that I would disagree. Though it was a good read, I must admit, and I have learned a lot from this. But I think it is clear from the ZTE Huawei decision that this dispute comes up after the parties have clashed over royalties.
Of course, everything is about.
And infringement is the way we go with it and the way we try to solve it at some point, because the patent holder is not satisfied. But the underlying commercial dispute is so clear under this. So maybe, well, we will probably disagree here.
You agree to disagree, yes.
Yeah, exactly.
Thank you very much. We will move to the next panel in which we'll discuss those issues from geopolitical perspective. Thank you.